Thank you. It's really nice to see that everybody's here in the afternoon because they just think civil procedure is so exciting, right? And I actually am kind of a civil procedure wonk. I hated it before, but I found that civil procedure gives you the rules of engagement. And once you know the rules of engagement, if you can get courts to apply the rules, it's just phenomenal what you can get. And so we're going to talk a lot today about the things you do to get courts to understand the significance of the rules. Well, I'm going to start with the concept, and we've been talking a lot today about credibility and getting information. And from my standpoint, I believe the most powerful evidence there is comes from the adversary. Because when you put a witness on, the jury's going to go, yeah, right, of course you put them on. You know, you want to win. But if you get information from your adversary, now you've got something. And that really sticks. And so, as we know, you take a deposition, right? So what we do is we ask, if we want to get information from our adversaries, who happen to be organizations, the government, corporations, we ask people questions, right? And they don't know anything. And they say, I don't know, ask somebody else, right? She knows. It's like the Kirby Puckett bobblehead, you know? Everyone's going to say it. It's, of course, you know? And you go witness after witness and after witness, and you're just hemorrhaging money. And you say, what's going on? No wonder this place is going down. Nobody knows squat. But in the meantime, you're not getting anything, and you're trying to prove your case through the other witnesses, and we know that they are trained to not know anything. They don't look at anything. They're isolated from documents. They're isolated from other testimony. And the defense lawyers work really hard, or if it's a plaintiff who's a corporation, they do the same thing. But they work really hard to insulate the witnesses from information because they don't want you to get anything. So the question is there another approach? Is there something different that we can do to get the information we want without hemorrhaging, without stalling, without getting the runaround in the Stonewall? Because I'd like you to just say, let's open up our minds. Let's be creative, and let's try to figure out a way to solve the problem of people jerking us around, okay? So, when we're dealing with organizations, 30B6 is a deposition about issue designation. You spend, 18, 19 seconds on it in law school? Did anybody even have an hour on it? And from my standpoint, and this is not because I've been writing a book on it for the last 15 years, but it's because I decided that this is one of the most powerful weapons there is. And what I'm hoping to do is share with you the big picture today of how you can use it in your practice. So we're going to start with what the rule is. 30B6 is not a deposition of a person that you're saying, I want to talk to Joe Blow or the engineer or the CFO. What it is a deposition based on issues that an organization has to produce a person, someone with blood running through their veins, to answer questions on matters on which examination is requested. Okay? So what does that mean? You tell them what you want to know, and they got to tell you. Done. We can leave now. Because that's all you really need to know about what the rule is if you want to understand the rule. You don't tell them who you want, you tell them what you want to know. And it's a powerful tool. And it doesn't just apply to corporations. I keep hearing people saying, oh, we got a corporate designee deposition. No, It's not a corporate designee. It's for corporations, partnerships, governmental agencies, associations, and other entities. So this is broad. This is really broad. And here's the thing is, an association is a really broad term. It's a collection of individuals, people who come together for a common purpose. It's really broad. And you know what? It doesn't even have to be a legal entity. It doesn't have to have a legal status. How do we know this? By that really deep, heavy research it's calling reading the rule and reading the committee notes. Because in 2007, 30b-6 was revised to add the term entity, and in the notes they said, this rule is designed to reach information known or reasonably available to an organization no matter what abstract fictive concept is used to describe the organization. Now, how broad, is there any possible way to make that any broader? Well, I can feel it out here, right? Because I've given this talk before. It says, well, wait a minute. They have to have some legal status if I'm going to sue them, right? Because you can't just sue a club or a landlord-tenant association. So what's the purpose of this? The purpose is it doesn't have to be the defendant or the plaintiff. It doesn't have to be a party. That's the thing that people don't get. It could be any organization. If you have an organization that has information you want to access, you can take the 30b-6. It could be a subrogated insurer. I get this all the time. You know, we want 100 cents on the dollar, and this is our insurance policy, and you got to pay it, and we're not going to tell you why. We're just going to put a lien on your case and then obstruct everything so you can't get anything. And they usually have some claims company, let's just make up a name out of the blue, Ingenex, and the claims people refuse to talk to you. You can do a 30b-6 of the underlying insurer and say, what is the basis of insurance? What statutes was it written under? Oh, it's an advantage policy that has Medicare and Medicaid, and you're supposed to disaggregate it. Tell me how you did it. And all of a sudden, people will start behaving because now they are forced to come and talk to you. Or you could do like, how about an auto dealer who inspected the car? Vendor product training. Let's say you've got a products liability case and you want to know how they train it, and the vendor is selling it. Hospital billings, where they won't tell you where the bills came from. Accounting firms that do regulatory compliance. Subcontractors, and my favorite is the IT company. The IT company is when you want to start getting to email of a small organization, why don't you just talk to the people about how it's set up and how it's stored, and is there an archive server? And now you don't have to deal with the adversary. You're dealing with a third party. So you've got all kinds of places you can get information as long as it's an organization of some sort. You'll find a lot of the cases out there are condominium associations, basically that, the club that everyone joins so that, they can, decide, how hot the water in the pool should be or something. So you can get all kinds of information. So that's cool, but people will always come to say, well, Mark, what are the logistics? Do I just get one, or what happens? Or I'm taking a 30b-6 and they said I've already deposed the person as an individual. So what I'd like to do is talk to you about some of the logistics here. And I'm going to be moving kind of fast here because we're trying to drink, from a fire hose here. So how about let's start with the first one. You got one 30b-6 notice, but they have a different person for every matter of inquiry. Why were side rails used for the bed for Willie Mae Powell? What were the defendant's policies for the side rails? What did Delta Rehab do to provide those side rails? And they say, well, we don't have anybody who knows that. We have to give you 3 people. And some people will get pissed off and say, well, I want somebody. So no, celebrate that. Because you know what that means? Multiple designees is 1 deposition. A case, and I'm going to point out the cases that I think are really important. Quality Aero Technology, Inc., 212 FRD 313. And it really says, a 30B6 deposition is separately counted as a single deposition regardless of the numbers of witnesses designated. And I'm unaware of any case that says anything differently. And I sit around and read this stuff at night because I don't have anything better to do with my life. So lots of designees, 1 deposition. And here's the cool part. Every time they give you a different person, you get a whole separate 7 hours. Because you know, we have the rule 30D that says a deposition is limited in time to 7 hours. Well, for the purposes, and this is again in the amendments, I'm not making this up, for the purposes of the limit, each person designated is considered a separate deposition for the 7-hour time period. So if they give you 3 witnesses, you got 21 hours without leave of the court. So bring it on, I'm good for it. I'm real good for that. How about if you want to have, though, lots of 30B6 deposition notices, not just 1, but multiples, which I do almost universally in every case I handle. But you need to understand that there are 2 schools of thought. Using Quality Aero, there is no aspect of the rule which restricts a party to a single deposition, a 30B6. There's a second school coming out of the sulfuric antitrust litigation, which is Westlaw 1994105, that says you need prior judicial approval if you're going to have multiple 30B6s, because you can only take the deposition of an individual once, and we all know that corporations are individuals, right? But there aren't enough cases to even claim a majority or minority position. There are less than 10 cases in the country on it. And the policy arguments can be very different. Because one of the things that the courts are very big on both state and federal levels now is proportionality. And what they like is sequenced discovery. They don't want you to do the big giant dump at the beginning. So one of the things you do is say, I want to do this in phases, in sequences, to see what we need in the future. Because we don't want to have unnecessary depositions, and we sure don't want to have our adversaries spend a lot of time doing things that are going to be unnecessary in the litigation. And you know, the courts have been pretty good about it. When people go for leave, the courts have stated that a court has got to be careful not to deprive a party of discovery that is reasonably necessary to afford a fair opportunity to develop and prepare the case. Because those cases where they limit the depositions to 1, all but 2 of them that I have read have been where the requesting party has asked the identical deposition notice a second time. They didn't like what they got. They're facing a summary judgment motion in a year, and bang, they're going for the same notice again. Because if you ask the same 30B6 deposition time and again, it does get cumulative. But you need to understand that the majority of the cases, and every case that I've ever litigated, and I've done hundreds of 30B6 depositions, we have multiples within a case because we sequence the discovery. So how about the situation, though? You want to take a 30B6 deposition of an organization and say, you already deposed the person. You get one bite of the apple, counsel. I'm ruling that you don't get the second one. No, wrong. Sabry versus First Domain, Westlaw 1590544 is the sentinel case on it. Stands for the proposition 30B6 deposition of a witness is separate from the deposition of the same person as an individual. And they're presumptively subject to a separate 7-hour limit. And you know, sometimes people want to note the deposition of an individual and 30B6 simultaneously. I'm thinking, why? Why on earth would you ever want to do that? Because you may want to take their deposition a separate time. If you take a 30B1 deposition of an individual, and if they're a managing agent, they will bind the organization. But they have no duty to prepare like they do in 30B6, which we're going to talk about later on. So the reason you would take a 30B1 of an individual, be it a design engineer or a managing agent or a CEO, is because it's important to your case to understand whether or not that person had knowledge of something, that that person in that department didn't know something. Then it's important. An example, the FDA learned that bed rails kill people, and there'd been like 400 deaths reported. A bed rail company is getting notices from the government saying, hey, these things are killing people. And the company unquestionably has that information. But the question is, are the design engineers getting that information? And so you may want to take the deposition of the design engineer to find out when all that information is coming in, is it getting to the design department? Then it's important. On the other hand, if you want to know whether the corporation knew that these bed rails were killing people, then the 30B6 is going to be the critical deposition you want, because what we'll learn as we go on, and I'll keep going over this for the next 2 hours, is the 30B6 represents all the information known to the organization. So the same person may be a designee, they may be an individual, you can depose them twice. But how about where it's at? Because people want to fight about this all the time. I'm going to tell you, first of all, if you're going to fight with your adversary about whether you're going to drive up to Memphis or go to Kansas City or not, and you're going to go to court over that, you're putting up a billboard that says, I don't have any money to handle this case, or it's a really small case. I'm not a big fan of telling my adversaries that my case isn't very big. So it's really a battle that is kind of a non-battle in my book, but picking the right location is not a non-battle. And so if you're taking a 30B6 of an adversary, in my case, it's universally a defendant, the principal place of business is a rebuttable presumption. It might be somewhere else, but it's the principal place of business. And they can change it. You know, you can go to court and say, look, all the counsel are somewhere, the designees are somewhere else. We may need the court. The documents might be somewhere else. I was handling a case in Tacoma, Washington, and there was this little company who was running a business out there called Walmart. And you know, I thought it would make sense that since we wanted all the information that was at the local store in Moses Lake, Washington, that it would make sense to take the depot there. And I noted it. So of course, junior partner calls, you know who I'm talking about, you know, wears the bow ties and the suspenders and has a tasseled loafers and drives a starter Beamer, you know? And you know, you apparently don't know the rules, Mark. It's got to be in the principal place of business in Bentonville. I said, fine, we'll change it to Bentonville or anywhere else you want. How about Paris? I'd be good with Paris. They'll never go to Paris. It's a joke. It's a joke. If you want to go to Bentonville, we'll do it in Bentonville. Well, I got to get permission for Bentonville. You see, they play this tough game. And so it's real important for you to know what the rule is. And you're not going to fight about it. And guess what? Then ultimately they wanted to do it in Moses Lake because they would have had to fly the people from up there down to Bentonville. So I just say, do it wherever you want. I don't care. No big deal. Just, I want the right person. But that's if you got a party. If you got a non-party, now all of a sudden you got a tension. Because a non-party has to be subpoenaed under Rule 45 or the state equivalent. And at least in the federal rule, it states that the designee's got to be within 100, the deposition's got to be within 100 miles of the residence or the area of employment of the designee. And what the cases say, okay, we got a tension here because, like all other laws, they're layered on top of each other, and sometimes they don't think through the conflicts. So they say, because this is someone who has no interest in the litigation, then we're going to have Rule 45 apply. And so they say, okay, we'll go to the principal place of business of this organization who's a non-party. They say, no. The non-party gets to pick the designee. And then it's going to be within 100 miles of the location of the designee. There are some exceptions, just I'm going to go parenthetically off to this. There was a big litigation with Iran when the assets of the bank were frozen, and so the lawyers for Iran said, no, you have to go to Iran for the depots, and the court said, nah, I don't think so. You're going to have to come here for that one. But as a general rule, it's going to be where they have the designee. And this is one of those nuances, it's this geek stuff, but it's important to know because you don't want to get into these brush fires and these little fights over where the deposition is going to be unless there's a risk of you being killed. Then it's worth fighting about. So entity versus designee, the location of the designee controls if it's a non-party. Deposition location of the party, corporate headquarters, non-party, where the designee is. So, what do we put in the notice? Let me get a drink of water. The transition point, that's what the black slide is. Okay, the notice, 30B6. This is the standard language we put in our notice. I have defendant, but it's actually the designee, if it's a non-party, has to designate someone who's an officer, director, managing agent, or person who consents to testify, who's fully prepared to talk about the designated matters that are known or reasonably available to the defendant's organization. You might notice that there's nothing about the person with most knowledge. The person with most knowledge is a word processing artifact that goes back before 30B6 was invented. And it was the rule that says if you don't know who the CEO or who a certain department head would be, they'd have the person with most knowledge. But the problem is the person with most knowledge may know 5% of the information, which doesn't do you any good, particularly if they have to hide from it. So the rule extracted that. And then unless you're practicing in California, which is the only state that still stands by that rule, the state and federal rules are all information known or reasonably available. So what you do is you've got the notice, and you set forth, you tell them what you want to know. Pretty straightforward. But telling them what you want to know is important, how you do it, because the quality of your answers is in direct proportion to the quality of your questions. And if that's good enough for Albert Einstein, it's probably good enough for us. So we really got to think about how we're going to craft these matters of examination within the notice. And we spend probably more time crafting that notice than actually taking the deposition. So we got to think about what's the law, because remember, we're going to that number one rule of legal research, which is doing it. And there's two schools. The rule, and one line of cases talks about reasonable particularity. Another line of cases say you've got to tell your adversary a roster of information with painstaking specificity. Now, I just threw up a couple of cases. Great American Insurance versus Vegas is good. And it just says, look, you got to give them reasonable notice, a reasonably particular identification of what you're looking for. But you go down to Sprint in the District of Kansas, where a lot of major 30b-6 law comes out, and the court said, no, you got to do a full roster of information with painstaking specificity as to what you're looking for. Two different standards, but in the end, like a lot of stuff in the law, it's just kind of like a bunch of weasel words. Because what it really stands for practically is the notice sufficiently limited in scope that it'll let the person or the entity know, a person with ordinary intelligence, what it is you want to ask them. Let them know what you want to know, because you're not a law professor anymore. Because what we learned in law school is we can just kind of throw all kinds of stuff out there. The real standard is the responding entities got to know the outer limits of what you expect them to be prepared to talk about. You got to let them know, because remember in law school, it was awesome. The law professor would come in and go, Mark, tell me precisely what thought is going through my mind right now. And he said, well,